everybody. This is Charles Dobens, the multifamily attorney and the founder of the Multifamily Investing Academy, and I'm back with my next week's version of the Multifamily Investing Academy podcast, my award-winning podcast. And I want to listen, this is going to be such a fun interview. I love this guest. For those of you that have been following me, you know I'm a huge TikTok fan, okay? And I check TikTok out all the time. There are a couple of people on TikTok that when they come up on my For You page, I stop everything I'm doing and I just listen. And this guest of mine is one of those people. Her name is Cristen Martinez. She's an attorney down in the Tampa, Florida area. And listen, I know all of you right now are now trying to jump on over and find her on TikTok. Cristen is spelled with a C. That's the inside buzz. So make sure if you're looking for it, starts with a C. Cristen Martinez. Cristen, thank you so much for coming on my show.
What a welcome. Thank you. I'm so honored.
Yes. Oh man, you have the best topics. I mean, it's like property law class all over again every time I listen to you. But the difference is that you actually have real life scenarios and that get applied to the law, which is so fun to listen to. Now, you're just a kid. I look at you, you're just a kid. How long have you been practicing law?
So this May will be 14 years. So I appreciate you saying that I look like a kid.
Wow. Holy cow. Good for you. I'm 72 years old. I don't know if you knew that, but you're supposed to say I look really good for 72, Cristen. That's what you're supposed to say. Okay,
I never comment on people's ages because you never know these days, but I always appreciate when people think I'm younger than I am.
I don't say anything about a woman's pregnancy until the head's coming out. All right? Even my own wife's kids. Like, I learned my lesson early on. No, don't even comment. So, all right, listen, obviously my audience are multifamily investors, and a lot of the topics that you have on your TikTok page really are things that we deal with all the time. And so I'm going to give you the topics that I've pretty much culled from your TikTok, whatever they call it, your channel. And I'm going to just throw out the topics and ask you like how it would apply to like some of my clients. So the first one has to do with working with contractors. And this is something that we're doing we're renovating hotels right now, and we're dealing with contractors from 1,000 miles away. But you give two good pieces of advice as far as checking them out, making sure they have good references. But the thing that I really want to ask you is, what types of provisions would you always recommend being in a contract with a contractor that bar none that they have to be in here?
Sure. So the biggest issues that we see with contractors are timing. When is the project going to be complete? And then quality of work or quality of the subcontractors that are being used on the project. So it is probably very rare that you're going to find a contractor that's willing to commit to a specific deadline for completion of the work, but you want to have at least a ballpark or a range or some sort of time period that is agreed to. And what happens if the contractor goes beyond that period? Are they in breach? Are you entitled to a certain discount off of the total price the longer they take beyond a certain point? Because a lot of times with investors especially, they're paying daily interest. The longer a project takes, the more money it's going to cost them. So if you leave it to the contractor and their kind of template or standard contracts they use, there's not going to be any sort of commitment to a deadline. So that's going to be the first thing I would suggest is, even if you can't commit to a hard deadline, put some sort of parameters in there so that both parties are on the same page about what the expectations are and what happens if those expectations are not met.
Now, you just mentioned a word in there that brought up another question for me. You talked about subs. One of the biggest problems is, how can you confirm and make sure that the subs are getting paid? Because that's one of the biggest problems is you think you're done, and all of a sudden there's a line of subs lining up at your door saying, hey, I haven't been paid yet. How do you protect against that?
Sure. So, what I would recommend is in your contract with your general contractor, there needs to be a draw schedule for payment. Don't pay it all at once. Don't pay, half at the beginning and half at the end. There needs to be specific draws, and you should require lien waivers from the subs doing a certain whatever portion of that work is, plumbing, for example. After the plumbing's done, another draw is due, but the contractor doesn't get that draw payment until a lien waiver is produced from the plumbing sub, for example. That's really the best way to protect yourself, because at the end of the day, even though you have this agreement with the general contractor, if a sub isn't paid, they get to lien their property and they will be able to foreclose that lien if they're not paid. So now you're looking at potentially having to pay twice if you find yourself in that situation.
Exactly. Okay. All right. Now, this next topic is going to be a fun one. All right. Because one of my clients made millions on this clause in the purchase and sale contract, and that has to do with specific performance. Okay. So let me just explain to everybody here what specific performance really is, especially in our purchase and sale contract. Under the remedies for default, if you look to see what are the remedies for default for the seller, remedies of default for the buyer, remedies of default against the seller could be you get your earnest money back and you walk away, or, well, actually it could be for both buyer and seller, but mostly we see it on the seller side, is they have to perform under the contract. They have to sell you the property. And one of my students, you'll never believe this one, Christina, the seller refused to perform because during the time that they were under contract, he got a better bid. He got from someone who could write the check. And he said, well, I'm not going to sell to my client. And he ended up paying $3 million to my client. My client made $3 million on a specific performance clause without ever owning the property. And so you see it a lot in your business. You deal with it quite a bit. Tell me some of the stories that you had with specific performance.
Sure. So specific performance is very interesting. It's a very interesting remedy. And we saw it a lot in kind of the market boom that we saw end of 2020, 2021, because sellers were doing exactly what you just said. They would get better offers coming along and they'd want to pursue or close with that buyer offering more money, offering cash, whatever the case may be. So on the buyer side, specific performance is a much easier remedy to enforce because you're not dealing with financing and lenders and all of these other factors that may contribute to whether a buyer can actually perform. So it's a great way to kind of hold the seller liable, because the whole time that the dispute is going on, the seller can't sell it to anybody else. That lawsuit is going to cloud title, and the seller either is going to lose the case and have to sell it to the buyer that's pursuing it. But even if they don't lose the case, they can't sell it to anybody in the meantime. So the likelihood is that they're going to lose whatever deal they wanted to terminate with the current buyer to go pursue anyway. So I find that most of those cases do settle because of that. And because sellers don't know what the market's going to do. The market may go down during the course of litigation, and now they're looking at taking much less for the property once the litigation is resolved. So we do see it happen a lot as far as lawsuits being filed for specific performance. But as far as actually going to trial on those issues, I find those are pretty rare, because those cases typically do settle because the seller really, it makes no sense for them to fight it in that case.
Okay, now I might be going down into the weeds a little bit here with legal talk, and I want to make sure everyone listening understands. Most purchase and sale contracts, there's a provision in it called no recordation, meaning we can't record. When a purchase and sale contract is an interest in land that can be recorded at the registry. If you have a no recordation clause, both parties agree we can't register that, because that, by recording it, you're essentially putting a cloud on that transfer. Now, how do you handle it, Christina, if your client agreed to a no recordation, and now you're having a specific performance issue? How do you cloud that title when it says no recordation? How do you go about that? What's the legal process?
Sure. So the only way in that case, the only legal way, I should say, to cloud title is to file a formal lawsuit for specific performance. And with that lawsuit, you file a notice of lis pendens. And a lis pendens is essentially just notice to the world that there is litigation ongoing related to this property, and that is going to cloud title. I do see you make me think of an interesting point, because I do see investors getting in trouble a lot for recording contracts or recording a memorandum of agreement to
Right.
purposely cloud title to save a deal. Aside from the language in the contract that may say neither party can record this contract, there's actually a Florida statute on point, and don't ask me what the Florida statute number is because I don't know, but it states that you can only record a contract or a memorandum if it is signed with the formalities of a deed, meaning you need it to be notarized and be signed before two subscribing witnesses. And you and I know that most all purchase contracts are not signed with those formalities, or a memorandum of agreement is typically not signed with those formalities. So even without the contractual provision saying you can't record it, if you record something that's not signed before a notary and two witnesses, I'm suing you for slander of title and for breach of that Florida statute. And that's where a lot of investors are getting tripped up.
Okay, folks in the Florida Tampa area, are you seeing why this young lady's such a great attorney? She's good. She's who you want. So if you're down there, this is who you want to have working for you, especially if you're a real estate investor. Okay, let me just talk to you for a moment about the memorandum issue. You know, up here, I'm up here in New England, and as a matter of fact, I'm up here in New England, but once we finish this conversation, I got to talk to you a little bit about Florida. Okay. All right. We'll talk about offline about that. All right. But you see, up here, we record everything. I mean, it's a full disclosure state, and as opposed to like Texas. So when you're dealing in Texas, you don't record the mortgages, you don't record the deeds, or you record the memorandum of mortgage or memorandum of lease. And so how does it work in Florida? Does it work similar to Texas, or, how do you handle that?
So here in Florida, the deed is recorded and then a mortgage is recorded. So we don't record memoranda, we record the actual deed and mortgage. What I was referring to is what a lot of investors here will do is, if they're under contract to purchase a property and they think the seller is not going to go through with the transaction, or they're going to try to pursue other offers, they will draft up a memorandum of agreement, which just essentially summarizes the purchase contract, and they'll record it under the legal description for that property so that they're clouding title essentially, so the seller can't sell it to anybody but them. And that's what I was saying, where people get in trouble, because they're not following the formalities required by the statute before recording those types of documents.
Okay, but they do have the ability to unilaterally, like the buyer could unilaterally file a memorandum of purchase and sale, walk into your office, you've got a notary in your office, you've got two witnesses, and you're good to go, right?
Yes, but it would be the seller's signature that would have to be notarized and witnessed. So the seller would have to cooperate in that process. Yes, if they were willing to sign, yes.
Okay. All right. Good. Great stuff. All right. Next topic, and this one is something that we come across all the time, and I want to get your professional opinion on all aspects. Airbnbs. Now, you put out a TikTok where you talked about Airbnbs and the problems that you were seeing in your law practice regarding these Airbnb owner operators. So give us some color on that from your perspective.
Sure. And I actually just posted an update this morning, so check that out if you
Okay,
haven't already.
good.
But
I haven't watched my TikTok yet, so I haven't seen it. So I will today, though.
You're slacking on me now.
I am slacking. I apologize.
No worries. So what we are seeing a lot is we're seeing this concept of rental arbitrage becoming more and more popular, where the person running the Airbnb doesn't actually own the property, they're renting it from the owner. And then during the lease term, during their tenancy, they're operating it as a short-term rental. And the mistake a lot of these Airbnb operators are making is they're either not getting consent from the property owner to do this, or they're using like a standard lease agreement, and they don't have proper provisions in the lease to account for the complications that could come up when running a short-term rental out of the property versus just your standard 12-month lease.
Okay. So what do you do to help? I mean, you've been, the story that you told, I think you were representing the property owner, and
Yes.
and the guy, man, was it your story where the person was like saying, "Oh, I'm not running an Airbnb." Yeah,
Yes.
I think
Yes.
that's, oh, folks, you got to go back and you got to find this one. This one's a good one because I bet you from all the people I know in this industry, I bet I know who was trying to pull a fast one on Cristen's client. And the story goes, and help me out with it. The story goes that you represent the owner who had
Yes.
leased the property to a tenant who, and you're not allowed to do Airbnb short-term rentals, but this guy's running an Airbnb business out of this guy's property and not disclosed in violation of the terms of the lease. And one thing that you did is I think you went on that guy's website and found that property being listed and said, "Hey, wait a minute."
We found it on Airbnb, and we also screen recorded a TikTok video that he made advertising the property as a short-term rental. So he did initially deny that it was a short-term rental. He said, "I just have lots of guests that sleep over at the home, but I'm staying there too. They're just my guests." At the hearing where we submitted that evidence, he didn't even show up because he knew. And we were able to successfully evict him.
Oh, that's great. That's great. So guys, listen, don't play fast ones. I mean, don't my advice to all my clients, don't sign a contract that you're going to be in violation of on day one. Just don't do it. And to hear that that's what this guy did. And you know what? I'll tell you something, Cristen. He's doing it to somebody else right now. He's got
and
some
that's
other...
the thing, and now this guy has an eviction on his record. So now if he goes to approach property owners and say, "Hey, I run a short-term rental business. Can I do this out of your property?" If they do their due diligence, they're going to see he now has an eviction on his record for not properly disclosing it. And that's going to cause huge issues for him. So, maybe he would have lost out on this one property if he had done it right. But now how many is he going to potentially lose out on because he has a record with an eviction on it now?
Exactly. Yeah. Yeah. Okay. Next topic. I got how much time? I'm doing all right with time, but I mean, listen, I could sit and talk to you about these first year law classes all over again. But here's the next one. Earnest money deposit. Okay. Now I am proudly been able to say that none of my clients have ever lost their earnest money deposit. I always make sure that it's drafted properly, but also they watch the time frames and also perform under the terms of the contract, so they can never be called upon and said, "Hey, well, you're supposed to do this and you didn't, so I'm keeping the money." So give us some story that you have regarding earnest money deposits, and then I want to talk to you about the legal process post breach.
Sure. And with earnest money deposits, and it may be different here in Florida because in Florida, we're a title state, we're not an attorney state. So most buyers are not represented by attorneys in negotiating the contract, signing the contract, and through closing, which in my opinion is a huge problem. So the vast majority of cases where we see they didn't understand the contract they signed, they didn't read the contract they signed, they missed a deadline. For example, here we have a financing deadline. So under the contract, if the buyer is denied financing within that time period, they can get out of the contract and get their earnest money back. However, most buyers think if I'm denied financing, period, I get to terminate and get my earnest money back. That's not the case. There's a specific deadline. So if you receive your denial outside of that deadline, you lose your deposit. And it usually takes getting into that situation before the average buyer realizes that. So the unfortunate thing with these is they are so easily prevented by having proper advice and counsel from an attorney in before you sign that contract, so you know exactly what you're signing, you know exactly what your obligations are, and you know what's going to happen if you don't comply with those obligations. So unfortunately, I don't have any sexy stories on these, because here in Florida it's typically as simple as that.
Wow. Okay, because you know, the financing contingency. People say that it's, you can quit, get your money back during the inspection period, no questions asked. And then I see people teaching this business where they're saying, and then the financing contingency, you can still get all your money back, no problem. And they don't follow up by saying that it's conditionally hard. In other words, your earnest money doesn't go hard until the end of the inspection period. And then when you go on beyond into the financing period, it's conditionally hard because you still have to do certain things. And that's where I've seen it come into play, where people don't understand the risks they take during the financing period of the contract. And you're absolutely right. We just had a deal, about 150 unit hotel that we're trying to buy. One of my students was trying to buy, and you just knew that the seller had not read the contract. He wasn't doing anything he was supposed to do. He had not read anything in the contract. And finally, we got the broker to admit, yeah, the guy hadn't read the contract. So you know what? Let's move on that one. But here's the thing I want you to explain. And this happened to a student of mine, and this was early on. I wish he had listened to me early on. And you hear me say students and clients because I have different types. This particular situation, the seller challenged the return of the earnest money deposit. And first mistake, and this is, I was not involved in the purchase and sale drafting. The earnest money was being held by the seller's attorney, which I mean, you're in a title state, so that it goes to the title company most times, the escrow agent. This one, the seller took the money, seller's attorney took the money, and then as soon as the guy said no, there's a dispute, they instantly filed an interpleader and with the court. Why don't you walk through those stages, those steps, filing the interpleader, having a hearing, going to court, and why you don't want to be in that situation?
Sure. So interpleader is interesting, and typically, at least here in Florida, title companies aren't very quick to file those. Obviously, attorneys' offices are different because they can do the work themselves. They're very familiar with the process. Title companies are saying, "Hey, I got to find an attorney. I got to hire them. I got to pay them." So they're a lot less likely to take that step quickly. But the risk to the parties, the buyer and seller, when an interpleader is filed, is the attorney's fees and the court costs incurred in filing that interpleader come right out of the deposit. So if you have a $10,000 deposit, it's probably going to be in the $1,000 to $2,000 range to get the interpleader filed. So right off the bat, you're down from fighting over $10,000 to now fighting over $8,000.
Right.
So in most cases, unless you're talking about a $50,000+ earnest money deposit, in most cases, I think the buyer and seller should be very, very, very motivated to work out some sort of compromise. The frustrating part in these cases is usually it's pretty clear based on the contract who's entitled to the deposit. That doesn't stop the other side from fighting it. But even in those cases, if I'm in my client's shoes, I'm wanting to work it out, because once attorney's fees and court costs get involved, that whittles down the deposit very quickly. But essentially, with the interpleader, the escrow agent, whoever's holding the money, files a formal lawsuit. They name buyer and seller as the defendant in that lawsuit. And essentially, they're telling the court, I have this money. I don't have any interest in it. I don't want it in my account anymore. So I'm going to deposit it in the registry of the court. And I have named the two people, buyer and seller, who may have an interest in the money, and they can now go fight about it. And at that point, it's up to the buyer and seller to respond and then assert their respective legal positions as far as why they believe they're entitled to that money.
Yeah, yeah. And in this particular case with my client, it was $10,000, and the opposing counsel, the buyer's attorney, see, the seller was in bankruptcy, so he didn't have any money. So he figured, what the heck? He found a lawyer to take this case on contingency. So it didn't cost him anything. And he said, let's just fight it. My client won, but it cost him $10,000. And, could have easily been solved, if everyone had understood the terms of the contract beforehand. So, yeah, it's, I mean, no lawyer likes to see it happen, but it happens. And, it's too bad. All right, let me ask you, coming in for a landing here, two final questions for you. We're doing hotel to apartment conversions, and one of the biggest things that we're having to deal with are zoning laws. Do you deal at all in any zoning issues, and what types of issues do you deal with?
We do not. So at my firm, we are exclusively real estate law, but that is limited to private parties. So essentially anything where the government is the opposing party, we don't get involved with that. That falls into the more administrative law realm, which the procedural rules are different. I'm not an expert in those things. And so for my firm and my business, I have decided to only handle those things that I am an extremely, experienced expert in. And so zoning, we do refer those issues out because I do think that's outside of kind of what we typically handle and what I'm comfortable handling.
It is such a unique.
It is. It's real estate, so people often think that we handle it, but it's a whole different animal as far as the laws that apply and the procedural rules.
I'll tell you, the way you just described it and that distinction makes it easy to understand. If the opposing party is the government, we don't get involved. Yeah.
Right. So that's typically going to be eminent domain issues, and zoning are the most common issues that we get asked about as a real estate law firm that we do not handle.
Oh, you don't handle eminent domain?
We do not, no.
Oh, isn't that interesting? Because here's my childhood house was taken through eminent domain.
Really?
Yeah. So the whole neighborhood was. And I'll tell you, so is taken through eminent domain. But okay, I guess the question I wanted to ask you, and this is now, you already taken me off on a tangent from my two questions. Adverse possession. Okay, so adverse possession. Let me just tell you. Of course, we all dig down into adverse possession in law school, and it's fascinating. I have a buddy who practically has made it a career in handling adverse possession cases in Massachusetts. I just thought it was such an, obscure part of the law that you learn it in law school, you'll never deal with it again. And he's made a career dealing with it. So how does adverse possession work for you in Florida? And, do you get a lot of these cases?
Sure. So we do handle adverse possession. It is not a claim that we commonly file because a lot of people call the office saying, hey, I want to file an adverse possession. We get that often, but the actual number of clients who have a legitimate claim for adverse possession is very small. Because at least here in Florida, most people know about the statutory period. You have to be in possession. It has to be open and obvious, those sorts of things. But here in Florida, you have to be paying taxes on that amount for the statutory period, which is 7 years in most cases. So
oh my God.
Usually for adverse possession, it is typically an error or a mistake in the legal description or in the boundaries where somebody thinks they own a certain strip of land or a certain piece of property. Everyone else thinks they own it. They're paying taxes on it because they think they own it, and they just discover that due to a mistake, they don't actually own it. That's typically the scenario, which again is rare, where we see adverse possession. The other area that we see it is with regard to easements. So you can obtain an easement over somebody's property through adverse possession. But as far as obtaining ownership or title to property, it is very rare because of having to pay the taxes because of that requirement.
I tell you, that would solve 95% of those cases if it came down to who's writing the check.
Yep.
That's, wow, Florida solved that problem pretty easily. That's
Yep.
amazing.
So we get people
Wow.
all the time, and there's even a little form with the county that you can fill out that, for adverse possession. You put it on file with the county, and then if it's on file for 7 years, people will come to me, but they're usually missing that, paying the property taxes on. That's usually
Yeah.
the element they're missing. So we
But
do,
but
deal with it often, but it's
you do have all the other elements of adverse possession, like open, continuous, exclusive, adverse, and
yes.
notorious. The old
Yes.
ocean. Okay, good.
Yes.
At least I remember something from that class. Okay. Now, Cristen, final question before I let you plug your firm, because I'm gonna plug it myself. Um, I saw something on a TikTok recently from you, so I have to ask this question: San Francisco or Kansas City?
Can I say neither? They asked me who I was rooting for in the last round of the playoffs, and I said the Ravens and the Lions, and we see how good that worked out.
Oh, yeah. Well, I like the Lions. I like the 49ers and the Lions. So, and
Okay.
I cannot believe the Lions
I
didn't show
know.
up in the second half.
I
Oh my
know.
gosh. Yeah, but
I
the
mean, I guess if I
Ravens.
had to choose, I would go with 49ers just because I'm kind of sick of hearing about the Chiefs and having them in the Super Bowl and having them winning
Yeah.
Super Bowls.
And now
But
you're sounding like a Patriots hater right now. I mean, I had to deal with people like you all those past
which
years.
I was
But
one of those until Tom Brady came to the Bucks.
wait,
Then I
why?
understood.
Oh, exactly. Okay. Yeah, exactly. Yes, I see what you're saying. Okay. Yeah. No, it's going to be, this one is, for me, it's all about Mr. Irrelevant.
Yeah.
Brock Purdy. Gotta give him his creds.
Yeah.
And I'm a Mahomes fan. When he was complaining about his wide receiver being offsides, so blatantly offside, like, why'd they throw the flag? Why? I mean, dude, Tom Brady was kicked out of the league for 4 games because his ball was too soft. And you're going to complain about that? Come on, man. Come on. So, hey, Cristen, thank you so much for being on the show. First up, guys, if you're looking for her on TikTok, it's Cristen Martinez. You got to spell Cristen with a C. You're never going to find her. You're going to find some other influencer out there. But you're down in the Tampa area. What's your law firm's website?
Sure. It is Martinez Law FLA as in Florida.com.
Awesome, guys. Yeah, if you're an investor down there, if you're buying real estate down there, you got to talk to this young lady. She's and track her on TikTok. Like and subscribe to her page. I think we're supposed to say something like that, and it gets her good reviews. But it's great. It's great entertainment. Every single time, I love watching her videos. So that's the best thing. Awesome. Thank you so much, Cristen. I so appreciate you being on our show today. Thank you.
Thank you for having me. I appreciate you as well.